QPRT paperwork was completed 3 weeks after I started it. Exactly as Marshall had projected. He called me on a Wednesday morning. Not a text, a call, which, from Marshall, means the news is worth the formality, and told me the qualified personal residence trust for 1,847 Palmetto Bluff Drive had been recorded with the Charleston County Register of Deeds. The house was no longer in my name personally. It was in a trust. I was listed as the sole beneficiary with exclusive right of occupancy for a term of 7 years. After that term, ownership would transfer to 3 Charleston charitable foundations with a directed payment of $200. 000 to the W.D. Reed Family Trust earmarked for Cody when he turned 25. What this meant in practical terms, the house was now outside the reach of any civil judgment against me. Nathan could win every lawsuit he filed, and he still could not touch the property. The listing agreement with Sullivan and Marsh was, as of that morning, worth exactly as much as the paper it was printed on. I thanked Marshall, hung up, and went to the kitchen to make coffee. Nathan was in the living room when I passed through. Laptop open. Doing something with documents. He glanced up. I noticed his eyes go to my face for a fraction of a second, reading me the way lawyers read rooms, and find nothing useful there. I nodded and continued to the kitchen. That afternoon, an envelope arrived by courier. Marshall called simultaneously. Nathan's attorney had filed the formal complaint with the Charleston County Court of Common Pleas. 2 counts. First, wrongful redistribution of jointly managed family assets. Second, diminished capacity, affecting sound financial decision-making. I read the complaint that evening. It was well drafted. I'll give them that. The diminished capacity argument was built around 3 things: the speed of the transfer, the timing relative to a family conflict, and the assertion that a man acting with full competence would not have moved $2 million within 48 hours of an argument. The argument was almost persuasive, which is the only kind worth making. I noted for the record that Nathan was a lawyer who understood how to draft a complaint designed to be difficult to dismiss quickly. The diminished capacity count in particular was strategic. It did not need to succeed at trial to be useful. It only needed to create enough uncertainty to motivate a settlement. A judge might appoint a guardian ad litem to review my finances pending the hearing. That could freeze the trust transfer review. That could cost months. Nathan knew this. Whoever had advised him on the strategy understood exactly what the procedural friction would accomplish. Even if the underlying argument failed, it was, I thought, a well-constructed trap. The kind that works on a man who acts impulsively, settles quickly, or has something to hide. I did not act impulsively. I had no inclination to settle on terms I hadn't chosen, and my documents were cleaner than the complaint suggested. What Nathan did not know, could not know, because the QPRT filing had happened that same morning, and public records take several days to update, was that while his attorney was finalizing the complaint, the house had already moved beyond his reach. By the time he discovered that, the recording would be an immovable fact in the county register. Marshall and I filed the acknowledgement of the complaint the following day. 1 sentence, and then filed our counterclaim the day after that. The counterclaim was specific. Unauthorized use of real property. Nathan and Stephanie had occupied 4 rooms of a 800 feet house for 38 months without a lease, without a rental agreement, and without contributing to utilities, property taxes, insurance. Hors maintenance. Marshall calculated the fair market rental rate for comparable properties in the Chestnut Hill neighborhood, $770 per month. 38 months at that rate. $10 by Lusher. We rounded to $67. $200 as a courtesy. We also filed the first notice of termination of residential license. The legal mechanism for removing an occupant who has no formal tenancy agreement, giving them 60 days. I asked Marshall to have the notice served personally at the house during business hours. I was in my study when it happened. I heard the door. I heard Stephanie's voice shift. Not the words. Just the particular register that changes when something unexpected has occurred and the performer has not yet decided how to respond. Then silence. Then heels on hardwood, moving quickly toward Nathan's home office. I did not go to the hallway. I returned to the document I had been reading. That evening, Rosen Burns texted me. Your son's car has been in the driveway 2 hours with the engine running. Everything all right? I replied, Fine. He's thinking. That night, Diana Foster sent a text at due zero. Check account at Truist Bank under S. Collins Reed. Balance, $340. Ling ling ling. Source is not Nathan. I read it twice. Then I put the phone face down on my desk and looked at the ceiling for a long moment. Thinking about the particular architecture of a plan that had been running alongside mine for 3 years without my knowledge, I met Diana at her office the following morning. She had several pages on the desk and a legal pad with numbers and columns. The $340, 000, had accumulated over roughly 2 years in regular deposits between $18, 000, and $22. Ling ling ling. All originating from a business account belonging to an LLC called SC Home Consult Group, registered in South Carolina. The registered director was Stephanie Collins Reed. The listed business purpose was interior design consulting. Her blog, I said. Some of it, Diana said. 14 clients paid SC Home Consult Group over 2 years. 8 of those 14 are business partners or principals at Sullivan & Marsh. Sullivan & Marsh, the firm holding the listing agreement on my house, signed by Nathan, contingent on my death or departure. I sat with that for a moment, not from shock, but from a kind of cold recognition. The people positioned to earn a sales commission on my house had also been paying my daughter-in-law for consulting services for 2 years while she lived in the house they were planning to sell. Is it illegal, I asked? Not inherently, Diana said, but if those payments were made in anticipation of a specific future transaction, and if the income wasn't fully reported, a competent attorney could raise both a conflict of interest argument in civil court and a separate question for the Department of Revenue. I called Marshall from the car. He listened, then said what I expected. Within our civil case, we could subpoena Stephanie's business records. Everything would enter the public record of the Charleston County Court. Every payment, every client, every transaction, and separately, entirely separately. Any citizen can provide information about potentially unreported income to the South Carolina Department of Revenue. That process would run on its own clock. I noted that, then I did something I had not done since Thanksgiving. I called Nathan. He picked up on the 4th ring. His voice was the voice of a man who had been anticipating this call for weeks and had still not prepared for it. Nathan, I said, I know about the account. I know about SC Home Consult Group. I know about Sullivan & Marsh. One beat. Talk to Marshall Cade before the hearing if you want to limit what becomes part of the public record. 5 seconds of silence. Dad, I can explain. I hung up, not from anger, because the call had done what it needed to do. He knew the full dimensions of what I knew, and what he chose to do with that information was his own decision. I had given him the door, the rest was his. The days that followed moved on 2 tracks. Marshall built our formal response to the complaint, a comprehensive filing that included the QPRT recording, the complete transaction audit for the trust transfer, and the attendance notes from the 2-attorney signing session, which served as contemporaneous evidence of sound mind and deliberate intent. Diana, meanwhile, confirmed 2 additional facts. Nathan carried a personal line of credit with $94, 000 outstanding, and his firm's quarterly billing had declined 17% in the last reported period. They needed the assets. That was always the explanation. Not malice as a thing unto itself, malice in service of a financial shortfall they hadn't told me about, and a lifestyle that required a solution they were not willing to earn. 4 days before the scheduled hearing, a settlement proposal arrived from Caldwell and Price. Nathan would withdraw the diminished capacity claim if I agreed to 3 things: restore him as a 25% beneficiary of the W.D. Reed Family Trust, extend their right of residence by 12 months, and this paragraph had Stephanie's fingerprints on every word, agree to a joint statement describing the Thanksgiving incident as a private family misunderstanding with no financial implications for any party. In other words, I would undo most of what I had done, and in exchange, they would stop doing what they were doing. I read it twice. set it on my desk next to the recorder. The listing agreement, the co-signer document, and Diana's report, 5 documents in a neat row. The complete structure of a 3-year plan visible at last in its proper sequence. I called Marshall. Counter offer. I said, they vacate voluntarily by April 1st. They sign a mutual release. Nathan remains excluded from the trust. Cody's beneficiary status is unchanged and untouchable. I paused. That's the only offer I'm making. Stephanie won't accept those terms. Marshall said, she won't. I agreed. But Nathan might when he finally reads the documents in front of him instead of the ones she's been handing him, and if they don't accept, then we go before Judge Taylor. And everything enters the public record, including the account, including the clients, including the LLC. I set the phone down. Outside, the Cooper River was dark and still. The counteroffer would be delivered the following morning. The hearing was 4 days away. Nathan had been a smart kid once, the kind who asked good questions about load-bearing walls. I had never stopped believing that somewhere underneath the last 6 years of comfortable compliance, that person still existed. I wasn't counting on it, but I hadn't stopped believing it either. There's a difference, and it matters. The settlement proposal from Caldwell and Price sat on my desk for 24 hours. Marshall had told me to take my time. I didn't need time. I needed the 24 hours to be on the record, so that no one could later argue I had acted impulsively. On the morning of the second day, I called Marshall and gave him my counteroffer. The terms were simple. Nathan and Stephanie would vacate 1,847 Palmetto Bluff Drive voluntarily by the first day of April. They would sign a mutual release. No further claims from either side. No litigation. No appeals. Nathan would remain excluded from the W.D. Reed Family Trust entirely. Cody's beneficiary status. Imeyan. Sube. Nulade Femoktu. Contingent on a university degree and no felony convictions. Would remain unchanged and untouchable. I would, in exchange, withdraw my counterclaim for the $67, 200 inches unpaid occupancy costs, provided Nathan signed a promissory note for $42. Ling ling ling, a reduction I considered more than fair, payable at $700 per month over 5 years. Those were the terms, all of them. Marshall relayed the counter the same afternoon. The response from Caldwell and Price came the following morning. Stefania, through her attorney, rejected it. Nathan, notably, did not respond separately. He had gone quiet in a way that was different from his earlier silences. Less strategic, more like a man trying to figure out which room he was actually standing in. 2 days passed, then a third. On the 4th day, the hearing was 1 week away. Marshall called me that afternoon with a specific tone I had learned to read over 11 years. The tone of a man who has new information and is organizing it as he speaks. Nathan's attorney contacted me directly. He said, Nathan wants to meet without Stephanie present. I sat with that for a moment, where I asked, he suggested your office. I told him you no longer have an office. He suggested coffee. I suggested my conference room. Fine. I said, set it. The meeting was 2 days before the hearing. Nathan came alone, which told me more than anything he said in the first 10 minutes. He looked like a man who had not been sleeping well, and not in the theatrical way people sometimes perform sleeplessness to generate sympathy, but in the specific way of someone whose thoughts had been too loud for several consecutive weeks. His hair was neat. His jacket was pressed, but his eyes had the quality of a man who had been reading documents at 20 inches the morning and not liking what he found. He sat across from me at Marshall's conference table and looked at his hands for a moment before he spoke. I noticed the particular stillness of someone who has spent days deciding what to say first and has not settled on it until this moment. I had not been in the same room as Nathan since Thanksgiving. 4 months. In that time, we had communicated exclusively through attorneys, through a process server at my front door, and through one phone call I had ended after 14 seconds. Sitting across a conference table from him now, I was struck by how much older he looked. Not in years, but in the specific way a person ages when they have been carrying something they should have put down a long time ago. I didn't know about the listing agreement, he said, not until after Thanksgiving. She showed it to me as she called it a contingency plan, something she'd arranged in case things went a certain way. A contingency plan for my death. I said, he didn't flinch, which I respected, or for you choosing to live somewhere else. She framed it that way, and the account at truest. A pause. I knew she had income from the blog. I didn't know about the LLC. I didn't know about Sullivan and Marsh. He looked up. I know how that sounds. It sounded exactly like what it was. A man who had been comfortable letting someone else make the decisions and was now sitting across from the consequences. I did not say that. I let the silence hold its own weight. What do you want? Nathan, I said finally. He straightened slightly. The way lawyers straighten when they are about to say something prepared. I want to accept your terms. All of them. I want to sign the mutual release. I want Cody's trust to stay exactly as you wrote it. He paused. I want this to stop. I looked at him for a long moment. The kid who used to ask about load-bearing walls, the kid who had sat beside me at a drafting table with genuine curiosity about how things held together, somewhere in the last 6 years. That person had walked into a room and let someone else rearrange all the furniture. You understand Cody stays in the trust on my original terms, I said. Not yours. Not Stefani's. Mine. Yes. And the promissory note, $0,000, at $700 a month. Yes. I nodded once. Talked to Marshall. I left the conference room and took the elevator down to Meeting Street. It was a cold afternoon. The kind where the light came off the harbor at a low angle and made everything look like a photograph of itself. I walked to my car and sat for a few minutes without starting it. The hearing was in 2 days. Stephanie still had her own attorney. She had not agreed to anything, but the structure had already decided the outcome, the way structures always do. Long before anyone picks up a hammer, the hearing before Judge Taylor of the Charleston County Court of Common Pleas lasted 3 hours and 40 minutes. I am going to tell you what it looked like from where I was sitting. Marshall presented 4 exhibits. The full transaction audit for the trust transfer, the competency documentation from the signing session, the QPRT recording filed with the county register, and the bank certification confirming that Nathan's co-signer status had never conferred ownership. By the time Marshall reached the 4th exhibit, the plaintiff's attorney, a capable man named Hess from Caldwell and Price, had the expression of someone identifying the exact moment a case had become structural. Nathan did not look at me once during the presentation. Stephanie sat beside him. Dark blazer, composed posture. The exterior she deploys when performing reasonableness in public. She held it for 40 minutes. I can tell you the precise moment it shifted. When Marshall placed the 4th exhibit on the record, Stephanie's left hand, flat on the table, closed into a fist, then opened, then her chin lifted by approximately half an inch, the way a person lifts their chin when a recalculation returns a worse number than expected. Hess argued professionally. The diminished capacity claim, unsupported by medical evidence and countered by Marshall's competency documentation, did not survive contact with the actual record. Judge Taylor asked 3 questions and then arranged his expression into the specific neutrality of a judge who had already decided and was completing the procedural arrival. The ruling took 20 minutes to read aloud. The wrongful redistribution claim dismissed. The diminished capacity claim dismissed. My counterclaim for unauthorized use of residential property sustained. The order, Nathan and Stephanie Reed were to vacate 1,847 Palmetto Bluff Drive on or before the last day of March. Nathan sat very still. Stephanie did not. Her composure, which had held through nearly 4 hours of a hearing that dismantled 2 years of planning 1 exhibit at a time, finally expressed itself, not loudly, but as Judge Taylor finished reading. She turned her head and looked at me across the courtroom, and her face had the expression of a person who has just confirmed that the building they planned to move into belonged to someone else's charitable trust and always would. The room began to empty. In the hallway, as I was putting on my coat, Stephanie appeared at my elbow. She had recovered most of her surface composure. Her voice was quiet. The voice she uses when she wants something to last. "You'll regret this," she said. I buttoned the top button and looked at her directly. "Stefania," I said. I spent 36 years building things meant to outlast me. I always know when a structure isn't viable. She held my gaze for 2 seconds. Then she walked toward the elevator where Nathan was waiting, his coat already on, his expression that of a man who had signed the mutual release and promissory note in Marshall's conference room the previous evening before any of this had happened. The paperwork was already filed. I watched them go. Stephanie was talking. Nathan was not responding. That was, in its small way, the first genuinely hopeful thing I had observed in 6 years. The last day of March was a Tuesday. I was on the front porch with coffee when the moving truck pulled up at 8. Stephanie directed from the doorway. Nathan carried boxes himself. His idea. I suspected. Not hers. Cody came out at 9:15 inches. His small jacket. Holding the stuffed bear I had given him at Christmas. He walked across the porch and hugged my leg without saying anything. I crouched down, told him I would see him soon. He nodded with the particular seriousness of a 4-year-old who understands the weight of something without understanding its contents. Nathan's car pulled around the drive. Cody was buckled in. I stood on the porch of 1,847 Palmetto Bluff Drive and watched until the car turned off the drive and was gone. What remained when the driveway was empty, $2 million in the W.D. Reed Family Trust. Untouched. The house in the QPRT, outside the reach of any future claim. Cody's $1. Sube. 0,25. Conditions unchanged. The promissory note for $42. 000. At $700 per month. Signed and filed. And a voluntary disclosure I had submitted to the South Carolina Department of Revenue after the hearing. Documents describing the financial history of SC Home Consult Group and its relationship with Sullivan and Marsh. What the department chose to do with that information was their own business entirely. 3 weeks later, I was at slip 7, working the final seams along the Claire's bow with a putty knife, the kind of work that requires patience, a steady hand, and an absolute refusal to rush what isn't ready. Rosen came down the dock with a pie tin covered in foil. And the expression of a woman who had been following a situation closely and had formed conclusions. Well, she said. How are you? I set down the putty knife. You know, Roslyn, I said, you can't build anything that lasts on ground that hasn't been properly prepared. Sometimes you have to clear the site before you can start. She studied me the way a retired magistrate studies a statement she finds mostly accurate, then set the pie tin on the bench beside her. I poured coffee from my thermos and looked out at the harbor. The phone in my pocket was quiet. The Claire smelled of fresh sawdust and marine varnish. The harbor was bright and still. There was nothing left unfinished that needed my attention today. It was a fine morning to be 68 years old in Charleston, South Carolina. If you like this story, please like this video, subscribe to the channel, and share your impressions of this story in the comments. To listen to the next story, click on the box on the left. Thank you for watching.